everybody, this is Abby Mabry. I am the Immigration Attorney with Cobb Law Group, and today we're going to do a little video on a topic called fact or fake. And the question for today is somebody who is undocumented or entered the United States illegally, or who doesn't have some sort of legal status, has a child who was born in the United States or who has become a citizen of the United States through naturalization. So they come in and they say, I have a child, he or she is a US citizen, and they're 21 years old, can they apply for me? So generally, we'll say the easy answer is yes, that child can submit an application for you. It is called an I-130 petition for an immediate relative. And what that petition does is it tells immigration essentially that I'm a US citizen, I have an immediate family member who doesn't have legal status, but we have this immediate family relationship, this parent-child relationship. So that's what that petition does. And the only evidence you really have to submit with that petition is proof that the petitioner is a US citizen and proof of the family relationship. So a US citizen child would submit this petition with their birth certificate showing they were born in the United States, or their naturalization certificate if they received their citizenship later in life, and also proof that they're applying for their biological parent. And immigration can approve that application, but that petition all by itself, that I-130 family petition, doesn't give you status standing alone. It really just is an opportunity to move on to the next step. Most people would be applying for residency, applying for a green card, right? There are some issues that come up there in this type of situation depending on how somebody entered the United States, in what manner they came into the United States, how many times they've entered the United States. So if you have a US citizen child who's 21 and wants to apply for you, the question then really becomes, how did you enter the United States? Do you have immigration violations on your record that we have to address with immigration for you to be able to get some sort of legal status? So if you entered the United States illegally, so that would be without inspection or admission or parole, then you have an illegal entry. That's an immigration violation that's on your record. Now, when that entry happened plays a part, and then if you've lived in the United States without legal status, you've also accrued what's called unlawful presence. That's just living in the United States for a certain period of time without legal status. So there's a particular waiver application that covers an illegal entry and unlawful presence. It's called a 601A provisional unlawful presence waiver. However, in order to be eligible for this waiver, you would have to prove that your removal or deportation from the United States would result in extreme hardship to a US citizen or lawful permanent resident, spouse, or parent. So you're not even eligible to apply for this waiver unless you are married to a US citizen or permanent resident, or you have parents that are US citizens or have permanent resident status. So if the only family member you have that has US citizen or permanent resident status is a child or even a sibling, then you're not going to be eligible for this particular waiver that you would need, this unlawful presence waiver. So that is really the more complicated answer to this question, can my child apply for me? Well, it really depends on how you entered the United States and what immigration violations you have on your record. So your son or daughter can submit an application for you. That immediate relative petition could get approved, but you won't be able to move on to the next step because you're not going to be eligible for the waiver that you need to waive your immigration violations. Now, if you enter the United States in a different way, so if you enter the United States, for example, let's say with a tourist visa, and maybe it happened, 30 years ago, and you never left, you just overstayed the visa. You had a US citizen child, that child wants to apply for you. because you entered the United States legally with a visa that was valid and current at the time, the visa was in your name, you didn't commit any type of fraud or misrepresentation to obtain the visa. Now, in this particular situation where you're applying for residency based on an immediate family relationship with a U.S. citizen, the immigration violation of unlawful presence, living in the United States without permission, is automatically waived. So how somebody entered the United States really makes a big difference on what they're going to be eligible for down the road if they're wanting to try to apply through a child who's a U.S. citizen who's 21 years old. And it really depends a lot on the facts. It depends on the facts of your entry, on the facts of your presence here, the circumstances surrounding that, and if you have immigration violations on your record, what are those violations? So really, when someone comes to ask me this question, I really have to sit down and have a more lengthy conversation with them to figure out what they're going to be eligible for, what they're not going to be eligible for, and if it's a good idea for them to even pursue certain applications depending on whether or not they're likely to be successful based on the way the law is written right now. So, fact or fake, can a U.S. citizen child apply for a parent? Technically, yes. So I hope that was helpful. I hope that helps everyone understand this issue a little bit better. And if there's anybody out there who has questions about this, wants to do a free immigration consultation, our door is always open. We're happy to get you scheduled, and we would love to meet you and see if we can help you. Thanks, everybody.